I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Abbott Laboratories versus Gardner, a U.S. Supreme Court case from 1967 about ripeness for review. In this case, the Supreme Court said was ripe for review, and the doctrine of ripeness in administrative law. By the way, as you can probably guess from the picture here, Abbott Laboratories is a big pharmaceutical company. Now, word for my students, or a word of introduction. First, there's a companion case to this case that's very important. Abbott Laboratories v. Gardner and Toilet Goods Association v. Gardner were put out by the Supreme Court on the same day, written by the same justice on the same subject. It's even the same agency or the same defendant in both cases, and different regulations are being challenged. And in one case, the court said it was ripe for review, and in the other, they said it was not. And they used these two cases basically to lay down the law about ripeness and set the parameters for the doctrine from then on. So if you only read one of these cases, I think you're only getting half of the holding or half of the rule. You really need to study them together to understand when we get ripeness and when we don't. So that's the first point, is we have two cases that are interconnected that you really need to read together. I am sure they're both, if they're in your administrative law casebook, both of them are there together. Okay, the second thing is, this is part of a section of administrative law that we call the timing of review. And there are three issues with timing of review, or subsections of that. And that's final agency action, ripeness, which is what this case is about, ripeness for review, and exhaustion of administrative remedies. All of these are about bringing a case into court, a challenge to an agency's decision or action, prematurely. And because they're all about premature litigation, and what it means, if you've litigated something prematurely, you're getting bounced out of court. Your case is going to get dismissed. And they all overlap in that sense, that they're all about the problem of people not liking something an agency did and running into court immediately too soon, and legally too soon. And that's what we mean when we talk about the timing of review. Now, a final agency action is when you have a case where we don't have a final decision yet from the agency, so it's premature to challenge it. Ripeness, we're going to talk about here. It's a little different. And exhaustion of remedies is when somebody failed to exhaust their administrative remedies. Because these all overlap in the general gist of being premature for judicial review, it's easy for law students to get them confused, and for lawyers to get them confused, and even judges. There's some famous cases where we have circuit court panels splitting, and where one thinks it's a final agency action issue and another ripeness, and so forth. But this is also an area that can generate malpractice claims against lawyers if you get it wrong, because the consequence of litigating something too early is that you may miss a deadline for addressing another remedy administratively, or asking for a reconsideration, or your client may have suffered some serious harms in the meantime. So out of everything I teach in administrative law, I hate to say it, timing of review, I think, is the area most likely to occasion a malpractice action against you when you're in practice. And so even if it's not heavily tested on your exam, this part of the course is very useful to get it straight in your mind now before you go into practice as an attorney. So let's look at what happens in Abbott Laboratories. Congress in the early 1960s passed some amendments to the Food, Drug, and Cosmetic Act, or FTCA, and that's where we're starting here with the statute. These amendments required pharmaceutical manufacturers to print the established name or generic name of a prescription drug prominently and in type at least half as large as that used thereon by any proprietary name or brand name on labels and other printed material. In other words, this is a labeling requirement. This is about requiring that the generic name of a drug appear on the label along with the brand name. I'm going to give you some examples, familiar examples with over-the-counter drugs, even though this regulation was about prescription drugs. If you buy a bottle of Tylenol, Tylenol is a brand name, and somewhere on the packaging, you're going to see the word acetaminophen, which is the chemical or generic name for that drug. If you like buying Motrin when you get a headache and taking Motrin, you've probably seen on the label that it says it's ibuprofen. So we have a generic name for a drug and then a brand name for a drug. And that's because of a regulation that they're required to put both of them on the label so that consumers don't get confused and think that one company's drug that's really just ibuprofen is different from somebody else's ibuprofen. And so the concern was about consumer confusion. This is about a labeling requirement, this case, for drugs, and the entire pharmaceutical industry challenging the regulation requiring that they were supposed to adjust their labels. Now, the FDA commissioner then promulgated regulations. So we've got the statutes, that's what I just talked about, and promulgated a regulation to implement the amendments to the statutes. And he took it one step further and required that the generic name accompany each appearance of the brand name or trade name anywhere on the labels, packaging, and advertisements. And so the entire pharmaceutical industry basically joined together with Abbott Laboratories in challenging the rule immediately. By the way, this is a picture of John W. Gardner, who was the secretary of the agency called Health, Education, and Welfare at the time. It's since been broken up into Health and Human Services and then a separate Department of Education. And at the time, the FDA was under his purview, or the umbrella of HUE. And so Gardner gets listed as the defendant in these cases, even though the court keeps talking about the FDA commissioner, who would have been Gardner's subordinate. Okay. The agency, which is the FDA, argued that the case was not ripe for review because they just published a final rule, but they hadn't enforced it yet against anyone. They had no immediate plans to enforce it against anyone. And the trial court agreed with this. And the argument was, look, if somebody's going to challenge the legality of the rule, they don't have to do that right now. They can wait until we enforce it against them and then raise that as a defense, as a type of affirmative defense. You can, fine, you're charging me with violating a rule, but the rule itself, the regulation, is not legally valid. So they could wait until an enforcement action to challenge the legal validity of this rule. And now, what was at stake for the drug manufacturers? They actually had a tragic choice here. So if they wanted to comply with the new regulation, that meant they had to immediately redo all of their labels and packaging and advertisements. This is very, very expensive for every one of their products. They might even have to recall product that had already been shipped out to pharmacies and stores nationwide to correct the labels and packaging on those, because they didn't have the generic name every single time. That's what the regulation required. Every single time, let's say you say Tylenol, you're also going to have to say acetaminophen in a font that's at least half as big as the font of the brand name. So you can put the brand name in a bigger font, but the regulation said you have to have them together. None of them were doing that. And so they were going to basically have to hold up production and shipping and things like that to redo every package, every label, every advertisement. Or they could ignore the rule and just wait around for an enforcement action. Maybe that would be a few years. Maybe it would never come. Maybe they'd never get caught. And then if they did, then they could challenge the rule's validity then. Well, there's a couple of problems with that. I hope you can see. So number one, sometimes there may have been a deadline. There's a lot of times deadlines for challenging the validity of a regulation, and the agency might wait until that deadline is passed to start enforcing the regulation. Secondly, let's say that they don't succeed in challenging the rule's legitimacy. Well, then they're going to be fined for years of non-compliance or violations, right? So if they wait around, let's say it's 5 years before the agency targets them for ignoring the regulation, the labeling rule. Well, if they lose that case, then they are on the hook for having violated it for 5 years continuously. So they wanted to bring a preemptive strike, get this settled right now at the outset. So the court in this case finds that the claim is ripe for review, and we need to talk about why, because the court reached the opposite result in the other case, in Toilet Goods Association versus Gardner. So first, the agency here, the FDA, contemplates immediate compliance by the regulated parties. They didn't say, we'll give you a grace period, or there was no grace period, at least put in the regulation. It goes into effect now. You're expected to comply now. And it would have immediate significant impact on the parties' businesses. They have to get busy redesigning and reprinting all of their packaging and labels and ads and so forth. Also, delaying judicial review wouldn't really serve any purpose because it wouldn't clarify legal issues. And I want to explain that to my students. Remember, the nature of the challenge here is that this regulation exceeded the agency's statutory authority. And so they had kind of maybe overstepped the boundaries of what Congress had authorized them to do in their enabling statute. That's at least what the pharmaceutical industry was saying. Well, think about it, that's a purely legal question. All we really need to know to decide if an agency is acting outside the scope of its statutory authority is, what does the statute say and what does the regulation say? And we have a final regulation. So waiting around for enforcement isn't really going to answer any more questions about whether this regulation kind of fills in some gaps in silence and is a reasonable interpretation of the statute and so forth. Please note this case predates Chevron. Or if the regulation contradicts or doesn't fit within the enabling statute. So there was nothing to gain for the court by waiting. Okay, let's go back and unpack this issue of ripeness just a little bit. So here's a big quote for you from these cases. Ripeness inquiry requires a court to evaluate both the fitness of the issues for judicial decision and the hardship to the parties of withholding court consideration. If you don't get anything else out of these cases or these videos, it's this, that we have a two-pronged test for ripeness: fitness for judicial decision and hardship of withholding or waiting. So now, why do we talk about ripeness? Well, the basic rationale behind ripeness is to prevent the courts, through premature adjudication, from entangling themselves in abstract disagreements over administrative policies, and also to protect the agencies from judicial meddling or interference until an administrative decision has been formalized and its effects felt in a concrete way by the challenging parties. The court here leaves us with a two-pronged test for ripeness for pre-enforcement review of agency regulations or decisions. The first is whether it's fit for review. Are the facts and issues already fully developed? And the second is hardship on the plaintiffs if judicial review is delayed until it can occur in the context of an enforcement action. You may have learned this in constitutional law, or at least heard ripeness mentioned, because both ripeness and its kind of cousin mootness arise from the case or controversy clause of the Constitution. In other words, we don't allow courts to just give advisory opinions on things or answer political questions, and we expect there to be a case or controversy. And so the idea of ripeness is a case is brought prematurely before there's really a case or controversy, and mootness is that it's brought too late. This is the case or controversy clause is Article 3, Section 2, Clause 1. The idea is that cases that are either premature, not ripe, or beyond the point of legal redress, moot, lack a sufficient legal controversy or interests to merit judicial review. Okay, so let's talk about fitness. What do we mean by it's fit for review? Well, a rule is fit for review, let's say, if there's no additional factual development required for the court to resolve the issue in the case. In other words, cases that are fit for review at the pre-enforcement stage typically involve purely legal issues. Here's an example: a challenge to the agency's authority under its enabling statutes to regulate in the area of the new rule would be a purely legal question, therefore fit for review. So I'm recording this in 2020. In the last year or two, the FDA has tried to regulate, let's say, vaping and e-cigarettes and so forth. And this is kind of a new territory. Or let's say the Treasury Department or the Securities and Exchange Commission decides to come in and regulate cryptocurrencies in a new way. And it's never done that before. So the question of whether their enabling statute allows that agency to even go into that new area is a purely legal question that would probably be fit for review. On the other hand, let's say there's a rule that's unclear in its meaning or application. That may lack fitness for review. And an example would be when an agency's new rule just calls for periodic site visits to check for regulatory compliance without any evidence of when or if the agency will conduct these inspections. That's actually the issue in the companion case to this one, Toilet Goods Association versus Gardner. It was this sort of vague, like, we're going to do inspections of buildings and you can't turn our inspectors away when they show up. And it doesn't really spell out any legal actions or rules in the same way that the regulation in this case did. Now let's talk about hardship. When a party can show that compliance with a newly promulgated rule would be extremely costly, and that waiting for enforcement proceedings to run their course would present special problems for those involved, this hardship helps satisfy the ripeness requirements for a judge reviewing agency regulations before the agency even begins enforcement. And in this case, remember, all of these drug manufacturers were going to have to redo all of their packaging and printing of the labels and the little inserts that come in the packaging and their ads and so forth. And that's a lot of time and money. And then there could also be this other special problem. What's a special problem? Something like a statutory deadline, let's say 2 years, for challenging the validity of a regulation after which judicial review is precluded. Well, those are all over the US Code. And so, and of course, an agency, if they're being clever, might just wait and not do much enforcement until they're past the deadline for challenging the validity of the regulation. Okay, here's a review question to see if you've been paying attention. I'm worried that you've gotten distracted or bored and stopped listening. What are the two factors in deciding whether an agency rule or decision is ripe for judicial review before enforcement? A, is the statute ambiguous, and is the agency's interpretation reasonable? Or B, fitness for review and hardship on the regulated parties if they wait for an enforcement action before challenging it. This was supposed to be easy, and if you're not sure about the answer to this one, you weren't paying attention and you need to rewatch the video. And that concludes our lecture about Abbott Laboratories v. Gardner. Make sure you watch the video for Toilet Goods Association v. Gardner so you can really understand both sides of the ripeness question from the Supreme Court standpoint.